Hello, this is Pujastri from the Tangal Nadar College. So I am going to discuss about the company's law subject, in that particularly formation of the company's topic. Now we'll see what is the formation of company. The stage of conceiving an idea to start a business and its working up is termed as promotion. The person who assumes the task of promotion are termed as promoter. Therefore, the promoter is a person who conceives an idea of starting a business, plans the formulation of that is company, and actually begins it into an existence. Formation of a company depends upon the promoters who is going to have the idea to start the business. He is the person who is going to perform all the tasks in that particular company that they are going to start for the particular vision. With the ideas and recruitment, everything is going to be taken care only with the help of the promoters. Promoter meaning a person who performs all the tasks is known as the promoter, who conceives the business and flexibility of ideas, assemble various resources, prepare necessary documents, and perform the other activities needed to commence the businesses. And the promoter is a person or a group of person or a company, which is going to be maintained by the particular person. A promoter can be one or two person, but he is the person who is going to take care of all the initial process of the starting of the company. Role of promoter. A promoter is like the starter or a parent of the company. It is defined in the section 2 subsection 69. Someone whose name is in the air of the company or the prospectus referred to it in the section 92, or someone who has influence over the board of directors as a shareholders or a director and is able to control the affairs, or as per the accordance to his guidance of advice and instructions, the board of directors are supposed to act provided that nothing in subclause C section shall apply to a person who is acting merely in a professional capacity. Continue with the promotion of the company. It is the first stage in the formation of a company. So it is going to refers to the discovery of a business opportunity and the subsequent organization of funds, property, and manageable abilities into a business concern for the purpose of making profit therefrom. The person who performs all the tasks during the promotion stage is known as a promoter. The promoter is a person who conceives the idea of starting a business, examines the feasibility of idea, assemble various resources, prepare necessary documents, and performs other activities needed to commence the business. A promoter can be a person or group of person or a company. Incorporation of the company. So, the incorporation of the company is a process by which a company becomes a legal entity. It can be compared to the birth of a company. So, what we are the human beings, that we are going to get the birth certificate. Like that, the incorporation certificate is the birth certificate of a particular company. But this is not called as the birth certificate, it is a certificate of incorporation. It is a legal process and is governed by the Companies Act 2013. Steps in the formation. Firstly, promotion, and then incorporation, subscription of capital, commencement of business. Promotion is the activity is going to be taken care by the promoter. He is going to do all the documentation. Every process is going to be taken care by the promoter. Incorporation also, by getting of the certificate of incorporation, by clearly specifying the unique name of the company, the certificate can be issued by the registrar of the companies. And then subscription of the company. The 90% minimum subscription has to be there for the companies for the initial offering, which is the first offer, public offer, initial public offering, which is IPO, And commencement of business is going to be, the commencement is going to happen only with the help of the certificate of commencement of business. Documents to be submitted to the register, MOA, which is used for the outside external people by stating every details about the companies. Articles of association. It can be maintained internally for the company. Consent of a proposed directors. Agreement. Statutory declaration. Process of incorporation. Approval of name. Preparation of documents, which is filing of the SPICE Inc. 32 form. Preparation of memorandum and articles of association. Filing of E-form number 32, consent of directors. E-form number 18, notice of registered address. E-form number 32, particulars of directors and statutory declaration in form number 1. Payment of registration fees. Certificate of incorporation from ROC. Memorandum of association. We'll go deeply, like memorandum of association, which is used outside. External people can refer it by knowing how well the company is going to be maintained. As per section 2 subsection 56, the Companies Act 2013 memorandum means the memorandum of association of a company as originally framed as altered from time to time in pursuance of any previous company law or this act. The below chart is going to represent the clauses of the memorandum, the contents of the memorandum. First one, name clause. It has to specify the name of the company. Second one, registered or office clause. It denotes the state name where the company is situated, registered office is situated. Object clause. It states the objective of the company. And liability clause. It's specifically saying that the liability of the members of the company. Capital clause. It specifies the details of the capital proposed in the company. Subscription clause. It states the member subscribing their signature in the memorandum. Articles of association. Notice to hold board meetings. Hold board meetings. Issue notice for extraordinary general meeting. Hold EGM. And lastly, filing of forms with ROC, which is Register of Companies. How can be altered articles of association according to the Companies Act 2013? Company can alter its article by way of addition, deletion, modification, substitution, or in any other way, only if it wants. To alter the articles of association of company by giving notice of at least 7 days at the board of meeting, the given resolution in respect of the alteration in AOA must be passed. Doctrine of constructive notice. The constructive notice is a legal entity shall have the knowledge or should be known as a reasonable person would have known of a legal action taken or going to be taken even if they don't have any real or actual knowledge of it. The doctrine of constructive notice, as according to the company's law, is a doctrine where all the persons dealing with the company are deemed to be knowledge of articles of association and memorandum of association of the companies. So doctrine of constructive notice is nothing but the every people who is going to indulge in the companies has to have the knowledge of the articles of association and memorandum of association. That is what is stated in the doctrine of constructive notice. Doctrine of ultra vires. A memorandum of association of a company is basically charter of a company. It is a binding document which describes the scope of the company, among other things. If a company departs from its MOA, such an act is ultra vires. An act, legal in itself, but not authorized by the object clause of the memorandum of association of a company or statute, is ultra vires the company. Hence, it is null and void. An act ultra vires the company cannot be ratified even by the unanimous consent of all the shareholders. If an act is ultra vires, the directors of a company, but in intra vires, the company itself then the members of the company can pass a resolution to ratify it. If an act is ultra virus, the articles of association of a company, then the same can be ratified by a special resolution or a general meeting. MOA versus AOA. MOA is defined as the section 2 subsection 56 and AOA is defined in section 2 subsection 5. It is subordinate to the Companies Act. It is subordinate to the memorandum. It can be amended later on. It can be amended in some cases. It should have at least 6 clauses. You can draft it as per rules and regulations. It is mandatory for all companies. If you are a public company that is limited by shares, you can use table A rather than AOA. You have to file it for sure at the time of registration. You need the approval of central government or a company law board, which is CLB, in order to alter it. Such approval is not needed in order to alter it, AOA. It defines the relation that a company has with outsiders. It deals with the relationship that a company has with its members as well as between the members. Prospectus. Definition of prospectus. A prospectus is a legal document issued by the company inviting the public to the subscription of the shares or debentures. Purpose of the prospectus is it serves a formal invitation to the public to invest in the company's securities. It discloses essential information about the company's operations, financial health, and future prospects to potential investors. Prospectus can vary based on the nature of the offering and stage of the company. Red herring prospectus. This is preliminary prospectus issued by a company prior to launching its initial public offering. It includes most of the details about the company's operations but does not contain the exact number of shares of the price and which the shares will be offered. Shelf prospectus. This type of prospectus allows a company to issue securities in part or tranches over a period without issuing a new prospectus for each offering. It valid for a period of specified in this prospectus, which can be up to 1 year. So prospectus, which is going to vary based on the nature of the offering and the stage of the company. Deemed prospectus. In case where an offer for a sale or invitation to the subscribe for securities is made by the company through a newspaper advertisement, this advertisement is considered as deemed prospectus. It must contain the same information that would required in prospectus. The rights issue prospectus. This prospectus is issued by a company when it offers additional shares to its existing shareholders. It provides details about the new shares being offered and terms of the rights issue. Abridged prospectus. This is a shorter version of the prospectus that contains the key information about the company securities being offered. It is typically used for the public offers and gives a brief overview of the potential investors. Offer for sale prospectus. When existing shareholders of a company offer their shares to public for sale, a prospectus detailing the terms of the sale is issued. Thank you.